If you say that there was $35,000 in a trunk at home and she took it and she says he took it, right? And you have a bunch of vile messages and everything else that make you look really bad, where do you think that credibility determination is going to go?
What is going on, everyone? It is Mark Reel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. And on today's episode, we're going to cover establishing paternity and why that's important, updates in the Jennifer Lopez and Ben Affleck divorce, and we're also going to talk about some unique issues in the Zach Bryan divorce. So here to discuss this with me today is managing attorney here at Real Father's Rights, Ryan Dreyer. How are we doing today, Ryan?
Doing great. Thanks for having me.
Awesome. So let's go ahead and hop right in. So I had an article cross my timeline, and the title of the article was, "Did you know unwed men must establish paternity to be recognized as the child's legal father?" So this seems like something that's common sense for us, and we deal with these things every day, and there's obviously been the increase in the number of children born to unwed parents. It's actually more common to be born to unwed parents than to wed parents now. So can you walk through the listeners what it means to establish paternity and why you need to establish paternity?
Yeah, absolutely. So if you're married, there's a presumption that any child born during that marriage is the child of the husband and wife, right? But it's different here. So women don't have to establish paternity because, or maternity because, well, they come from the woman, right? It's pretty common sense. But when we're looking at paternity, there's a couple things we have to do to establish. One is this the child of the person we're purporting it to be? So part of that is if you're at the hospital and say you've got a good relationship, you're going to sign a voluntary declaration of paternity, right? That's going to be used later in a paternity case. Hey, this has already been established. However, there's also where, hey, maybe mom and dad don't have a good relationship. Dad isn't there, or dad doesn't even know he has a kid. Well, then we're going to have to file what's a petition to establish parental rights. In that, we make a determination that the man is the father of the child. We can do it a couple different ways. One, if they just say, yes, I am that child. But the other is they can ask for a paternity test to prove and establish paternity. A lot of times this comes up, the issue of paternity, in establishing child support. So say there might be a man that doesn't even know he has a child or doesn't think that that child is his. Perhaps mom was dating several people at the time. Perhaps it was a one-night stand. These things happen. Child support must establish paternity of a person before, or of a man, before they can get a support order against them. Yeah. Now, if you believe a child isn't yours, then you need to challenge paternity. If there has been a presumed or an established paternity, it's on you within, I believe it's 2 years, to refute that presumed paternity. And that comes in marriage cases. But yes, you have to establish, to have legal rights to a child. If you want to be able to enforce your custodial rights, you have to get a judgment of paternity on it, right? Because a police officer, if they can't establish, oh, you're the father, there's nothing there for that, they're not going to force mom to turn over the child. You're going to need a court order that says, hey, I'm the father, and these are my rights, and this is my custodial time. This is also important to establish rights for a child to receive benefits under Social Security, state benefits, any of those other things. You need the establishment of paternity. It also will give the child the right to an inheritance from you, especially through probate if there's not a will. Obviously, you can leave whoever you want, child or not, whatever money you have. But there's certain protections for minor children and other and children of your body.
Yeah. So we'll roll it back. You said some interesting things there, and I want to kind of parse through. So number one is, if you're married, when the child is born. And we've actually had cases like this where you're going through divorce, another man gets her pregnant, but you're still legally married, you are presumed the father. So the easiest way is you're married. If you're married, it's presumed yours. You will automatically be on the birth certificate. The second way is that if you are not married, I think the common phrase that's used is you sign the birth certificate, but you sign that voluntary declaration of paternity. Now, this in a lot of parenting communities is a hot topic, is paternity testing. If you are not married, you're entitled to paternity. Actually, you're entitled to paternity testing, period. But if you're not married, you're entitled to paternity testing. Now, I'm the individual who I say that if there's any question at all, you should get a paternity test. I will not go as far as saying that paternity tests should be mandatory. That's more of a belief of if you don't want government interference, you don't have to have government interference. But that's personal opinion of me, not of anybody else. So you can sign that voluntary declaration of paternity, no paternity test, anything else. You're on the birth certificate, and you have the same rights as mom.
Absolutely.
Now, the second way kind of veers one of two ways that we see. One is you take it into your own hands or mom files. You file in court, and the first thing in a parentage action that has to be established is you are the lawful father of this child. Now, both parties can just simply agree in court, and you sign a couple forms, and voila, it's there. If there's any question from either party, then the judge would order paternity testing. And you have to go through the whole song and dance of the father and the child both getting tested. The other way that we see it happen is through the Department of Child Support Services. And a lot of times what we see is mom goes and gets state benefits. She may have not told the dad. Dad may not be involved. He may be trying to get her to do it outside, or they may be trying to do it outside of court. And mom goes and gets CalFresh or goes and gets food stamps of some any sort of state benefit, and they actually have to sign over the right to child support in receiving those benefits. Well, then the state's going to go after and try to recover some of that money. But the funny ones are when we see parents that are working together and maybe dad didn't sign the voluntary declaration of paternity, but then mom goes and gets food stamps and they're on friendly terms. They're working together. He may or may not be giving her money. They may have a custody arrangement in place. But now all of a sudden the state's going after who's the father. We need to go get this money back from him.
Right. Well, and that's the thing, right? The state will have their due, and that's a far worse creditor. I mean, a far worse creditor to have going against you, right?
Yeah.
No one wants the power of the state against you because they can do things to you that regular people in the courts won't do, like take your license, suspend your right to travel, take professional licenses.
Yeah.
I mean, it's like the mafia coming to collect on their debts. They will get their due.
And I'll call out the state of California on this. California actually has the highest percentage of child support paid that goes to the state of any state in the United States. 13% of what is paid in child support actually goes to the state, not the parent receiving child support.
Wow,
So,
I didn't know that.
yeah, so I mean, there are administrative costs. Every state has, and there's interest, and there's all these other things that occur. Or you have California, we have a ton of people on welfare programs, and the state keeps part of the money. Like we see a lot of times, parents will be angry. They'll be like, "I only got $200, but he's supposed to be paying $415." And well, he's paying $415, but the state's taking their cut for your benefits
Right.
before you get anything. So, I mean, I think the key lesson in that is, number one is you have no rights unless paternity has been established.
Yep.
So that's a key, and I think it's an issue we're going to see more and more of as fewer and fewer people are getting married, more and more kids are even born out of long-term relationships of people who just don't plan on getting married.
Right. They've just, for whatever reason, don't want to have the social contract there. Let me say one other thing about child support, ladies and gentlemen. It's 10% interest. I'm sure you would love 10% on all your investments,
Yeah.
right? 10% interest that they're going to hit. That catches up with you fast. How many cases do we have where they owe more in interest than they owe in principal, right? And there's so many. So be cognizant of that. Especially with DCSS, they're coming after you for 10% interest. Crazy.
Definitely. All right, so we're moving on. Last week, had Scotty on, and we talked all things J-Lo and Ben Affleck. So J-Lo and Ben are on its face doing it like the common man would. J-Lo filed pro per. There's no prenup. There's a lot of things going on in the case. Well, some news came out this week. Some more anecdotal and kind of, in my eyes, comical. Others interesting from a legal perspective. So first thing was, and not really anything surprising, so J-Lo, the female, filed. So we know 70 to 80% of petitions are filed by the female, whether it be divorce or parentage or any of these. And now she's saying she's torn and upset because Ben wasn't willing to work it out, yet she was the one who filed. I'll leave the listeners to their thoughts on that. The second piece is, we knew last week there was no prenup, which there may be reasons for that. Both of them, Ben's worth $150,000 or $150 million. J-Lo's worth $400 million. They're both in their 50s. There's a good chance that a great deal of their wealth and estate has been put into a trust, so they don't really have any personal assets. But it did come out that they have a $60 million Brentwood home that they purchased back in May. So with no prenup, and it was clearly purchased during the marriage, it appears that we have a fairly large piece of community property.
Yeah, absolutely. Remember, any asset purchased during marriage is presumed community property unless you can trace it to a separate property source. I doubt that happened here. Now, they both have, obviously, separate property estates. So I think it would be interesting. Did they actually take out a loan? Do people like this? I know people still take out loans on houses even when they can afford it, because especially if interest rates are low or anything else.
Yeah.
There's many financial reasons they do that. So if it is financed, we also need to look at what did they put down as their separate property reimbursement. Because remember, if say it's $60 million and Ben put down $20 million and Jennifer put down $20 million, if you can trace it to your separate property estate, which again, it's a short-term marriage, I'm sure that they can, they get that $20 million down dollar for dollar. You don't get any interest or appreciation, but they get that money back, right? And then the next is, well, who's going to take the house? Has it appreciated? It probably hasn't appreciated that much since May.
You may have lost money with the interest rates.
Exactly. So that would be interesting, is like, who's getting stuck with it? Are they just going to sell it? Or is one party going to buy out the other party?
Yeah, and so part of the report was that J-Lo apparently is still living there, and Ben has rented a home. But let's go back and let's talk about, first, before we get into that part of it, let's talk about kind of how this typically plays out in the cases we handle. We see a lot of, and it's the landscape's rapidly changing, but we still see quite a few instances where one spouse, typically the man, is the breadwinner. The wife is stay-at-home wife or works a part-time job or doesn't make a ton of money, and they bought a house. Mm-hmm. And they bought a house, we'll say, 5 years ago. And all of the money for the home has come from the husband's salary. Does that matter in the state of California?
It does not. If his labor, look, the community owns your labor during marriage, absent a prenuptial agreement, right? That also comes to anything your employer pays, so the money go into your 401k, everything. But if it just comes from your salary, it is 100% community property, and therefore anything that's bought with it is community property, beyond the presumption already that if it's purchased during marriage, it's community property.
Yeah.
So it's a double whammy there.
Yeah, it starts out, all of this stuff, if it happens during marriage, it is presumed, and you're going to have to go prove to the courts otherwise. So understand that starting point is that it's going to be split. So we see a lot of cases where one spouse is a pretty high earner, and then they have kids, and so the spouse that makes less steps away from the workforce. Mm-hmm. Well, unfortunately, once you're married, absent a prenup or a postnup, the state of California views you as one. These two people, it's your earning power combined. It's all your money.
It's a single economic community. It's a partnership,
Yeah.
which I wish, because everything that's bought, the court's like, yes, that's a partnership. Good job. You went out and got those extra investments, and you made those investments during marriage. Great job. Now, I wish the state of California would remember that when they're ordering child custody, that one was out and one was taking care of the children, and that guy still came home every night, and he saw his kids every night, and it should not be held against him because they were in a single economic community partnership. Yeah. I'll get off my soapbox. That's another thing entirely, but I wish it went both ways.
Yeah. Well, we're seeing the tides turn on that too.
We are.
More and more women are the breadwinners now, and I think that's going to be the fewer marriages and more women as the breadwinners. I think are going to be two trends we're going to see. But let's talk about the next piece. Was Ben has allegedly moved out of the home, and J-Lo is still in the home. Now we don't know the. We'll just say they're paying it as if they were the same way they were paying it when they were married. One of the things we deal with a lot when a couple is going through divorce and it hasn't been finalized is one spouse stays in the house, the other one moves out. And so typically you see argument over what we refer to as Watson Epstein credits. Can you talk to the listeners about what those mean and who may be entitled to them?
Yeah, absolutely. So usually in one of these circumstances, one of the spouses has moved out like we have in Ben, right? So the person that continues to pay the mortgage, right, gets an Epstein credit because you are paying a community property obligation, that mortgage, with your income post-separation, which makes it separate property. So you are using your separate property to pay a community property debt. That gives you the right to seek a credit or reimbursement for your expenditures, right? And so generally we have that. All right, regardless of who was living there, it doesn't matter who was living there, it matters who paid that mortgage. Now, the counterpart of that, and we call that an Epstein credit based on case law in Ray marriage of Epstein, right? Now, on the flip side, we have what are called Watts charges. Watts charges are for the use of a community property asset by one party without the other party getting the benefit of that asset. So, say we have a house, and let's just take in Ben's, right? Ben's moved out, J-Lo's staying there. We would look at, well, what's the reasonable rental value of that house per month?
What do you think the rental value of a $60 million?
That's what I was just wondering. Like, what is that? Is that $200,000 a month? Is that I have no idea, right? That's a big house, right? Yeah. So usually, Epstein credits and Watts charges can cancel out. So say if you're living in the house, right, and you're paying the mortgage, but you're living there, those two are going to basically cancel out. But we have different permutations. What if there's no mortgage? Or what if the out spouse is paying that mortgage while the other spouse continues to reside there? Because let's say it's a $5,000 a month fair market value for rent. Well, realistically, the spouse in the house is going to owe half of that back, right? Because there's a $2,500 benefit that the out spouse is not getting and the in spouse is. So they have to pay for the reasonable use of that asset. And so that can be a big swing where the one spouse remains in, but the out spouse is paying the mortgage. You can have huge amounts. I mean, I've seen $100,000 Watts charges. Yeah. Say they're in for 2 years while the divorce is ongoing, and the out spouse is continuing to pay at $2,500, right, over a 2-year time period. That's a lot of money. Yeah. Right? And so that's the basics in it. And it really arises, especially if the house is completely paid off, then it becomes also a major issue as well.
Yeah. So in short, we talk about the marital economic community. That house is a piece of community property. But that marital economic community ends at separation.
Correct.
Which really usually the latest date on a separation is going to be the filing of the divorce petition. But you have this asset that's still a community asset, but there's no longer any community labor, community income from it. So
Right. So let's look at it another way. What if they both moved out and then they used that as a rental property, right? They would still, because it's community property, have a right after expenditures to equally share in that rental value. So it's just a continuation of that, right?
Yeah.
Again, it's cut in half because the spouse still gets credit for their 1/2 ownership interest in that home.
yeah, definitely. Yeah, and that's the common one you see is the spouse that's earning money has the ability to move out and does, then gets stuck with the mortgage, and you have a spouse that's not paying the mortgage living in the house, and you get that spouse that's paying is entitled to get that money back because it's separate property, and then they're entitled to the benefit of that community asset.
Well, yeah, because even if, a lot of times they have to move out, right? But they're not getting any benefit from that property anymore. But they also can't stop paying because that's your credit, buddy, right? That's your credit. That's going to ruin your ability to buy a house in the future, right? On any of that.
That's a conversation we have to have a lot, is do you really want to trust her to pay this mortgage? A common one is you'll see with spouse, you'll try to negotiate, he'll pay the mortgage in lieu of X amount of money of temporary child or spousal support. So you can maintain control of that payment and your credit history and all that stuff, and she's not double or triple dipping in terms of the benefit she's receiving.
Exactly.
All right, so we've beat Bennifer to death here. So we have another celebrity divorce that brings up some interesting issues. A little bit of an older divorce case, but it's got some interesting twists. So country singer Zac Brown got divorced in 2023, late 2023. They actually separated only 9 days after they were married.
By a Zoom phone call.
Yeah. So
Yeah.
This is an issue that we get asked the question. I'm not going to say it's common, but one of the words used in the article was annulment, which is something that's not really easy to acquire in the state of California. I've personally handled a case where the guy called 3 days after their courthouse wedding. I asked him why he needed an annulment, and he said, her parents don't like me. So, Ryan, someone calls in and they're only weeks into their marriage. Is it realistic to think they're going to be able to get an annulment, or is this going to be a full-on divorce?
It's going to be a divorce. It is not realistic to get an annulment. I think I've gotten it one time, and I've actually had like a 10-day trial where we've litigated it, where the client, my client, actually had dementia. He had, it wasn't moderate, it was the beginning stages of dementia, but again, was not with it, could barely understand. All it was required to prove is that he understood at the time he was getting married. Not that he understood the ramifications or anything else. Yeah. The burden for marriage is so low. You just have to know you're doing it. Not why, not that you have your faculties, not that, hey, this person's going to try to take me for a ride. So there's statutory requirements for annulment. It's not just, oops, whoopsie, it's a mistake. It's not Friends, Ross and Rachel getting married in Las Vegas, right? It's not that. You can be drunk as a skunk. That's not a basis for an annulment. The basis for annulment is fraud, physical deformity or abnormality. It's not even that you guys never had sex. People think, oh, the marriage was never consummated, so that's an annulment. That is not true.
Yeah.
It is not true. The only way you could get on that basis would be, say, if you told the other side, let's wait till marriage, I can have children, I have a fully working, I have the fully working equipment
Yeah.
Right. And if it turns out you were unable to, yeah, that might be some fraud. So that you in fact did not have a penis. Right.
Yeah.
And were unable to. But other than that,
2024.
right.
Better do your due diligence.
Yeah. Other than that, there is some for fraud based on like immigration status, things like that. Yeah. The biggest one is bigamy. Were they already married, or did they separate but they never terminated their marriage? That would probably be the easiest because it's void ab initio, as they say. It never was a marriage because they were already married. But I mean, that's it.
That's one we've dealt with before. Telling me you can't get married, it's going to be void because you haven't officially gotten divorced from your first wife.
And we have run into that, and like, how quick can I do it, and all of that. I mean, I've heard of people even running to Guam because they have less waiting time on a divorce there. I don't know if that's very practicable for most people.
What was it? I think it's like the Dominican Republic has no notice divorce. So if your spouse is adamant about going to the DR, a prolonged vacation in the Dominican Republic. So with that, there's been some interesting filings in this case. Not necessarily family law, but I think they're tangentially related to family law. And both parties have filed civil lawsuits against the other party. So Zach Brown's ex-wife is a creative. She's a poet. She writes. He filed a TRO in federal court to restrict her from publishing works that were basically about him. And the more interesting one, a funny one, is she has recently filed a lawsuit because in one of his music videos, she's alleging that he used footage from their wedding party, but the bride is clearly not her. Now, Zach's claiming it was filmed back in 2018 and there's no way it could be. Who knows? I think both of them kind of die their own slow, painful deaths in terms of lawsuits. But this brings up a bigger issue that we see with a lot of men, and that is how you treat and how you communicate and how you work with your soon-to-be ex-spouse can have a huge impact on what occurs in your divorce.
I mean, 100%. If you think, okay, it's supposed to be a no-fault divorce state. Supposed to be. But if you think that judges won't look at, say you're sending vile messages, right? See you next Tuesday, all of those words, and you're directing that. It might not be emotional abuse, or it might not be domestic violence, right?
It probably is in California, but that's another conversation.
Soon we're going to have dirty stares be part of domestic violence as well, right?
Mad dog someone and get a DVRO.
It's going that way once they brought in the whole coercive control element. But if you think that a judge is not a person and doesn't have an opinion as to which party is problematic, it goes into their rulings, right? If they need to make a credibility determination and they don't like your conduct, who do you think they're going to come down on the side of? If you say, and I've talked about this, that there was $35,000 in a trunk at home and she took it, and she says he took it, right? And you have a bunch of vile messages and everything else that make you look really bad. Where do you think that credibility determination is going to go, right? What do you think is going to tip it in there? And when we're talking about
custody, he said, she said situations about finances, sanctions.
Yeah, absolutely. Family Code 271 sanctions, which is for conduct that frustrates the policy of the law towards settlement, right? And because you get into these where they're both trashing each other on social media or these other things, or here we have creative rights where each one is saying, hey, they're using my likeness or description. But right, isn't that part of what we love? Where would Taylor Swift be without her songs bashing her ex-boyfriends, right? Yeah. Like, good art comes out of trauma and out of pain, right? At least that's what some people say. We're lawyers. We're not really qualified to talk about art, but
both of them are kind of a stretch.
Yes,
you're trying to get a restraining order, restraining a creative from writing, and then who knows on the video of the wedding party. I think they've kind of admitted it's not her as the bride. So I really, even if it was their wedding party and they edited her out and put someone else's face, I don't even know how you could, what argument she would have.
Right. I mean, it's just fair use, right? It's not slander or false light or defamation, right? Yeah. And that's always funny, too, when people are like, they slandered me in court documents or other things. There's something called the litigation privilege. You get away with an awful lot in a courtroom, right?
Yeah.
What have we seen? I mean, just the slanderous allegations you see in a DV, and all that. And are they really ever held accountable? Rarely.
Outside of bad faith and an extreme allegation, the only situations I've seen where there's any sort of accountability is like you make rape allegations that are proven to be demonstratively false. I've seen attorneys actually get caught up in that for allowing things that were clearly false to be filed. But outside of extreme allegations, you're not going to see it. And then this divorce, they're already divorced.
Right.
They're just bickering back and forth on. Why aren't they moving on with their lives would be my first question.
I mean, generally, that's the way to go, right? Yeah, it's not a great look. They're still going at each other. And then it's obviously, they have things against each other. And so they're just taking their personal fight and putting it in a public forum, which to me is never a good look.
Never, never. All right, well, Ryan, thank you so much for your time today. To our viewers and listeners, thank you for watching or listening to another episode of the Father's Rights Playbook, and we'll be back again next week with a new episode. We'll see you guys soon.